start. That takes us to the merits of the respondent's contention that the conclusion of the appellant that the charge framed against the respondent had been proved is based on no evidence. Stop. The learned Attorney General has stressed before us that in dealing with this question, we ought to bear in mind the fact that the appellant is acting with the determination to root out corruption, and so if it is shown that the view taken by the appellant is reasonably possible, this court should not sit in appeal over that decision and seek to decide whether this court would have taken the same view or not. Stop. This contention is no doubt absolutely sound. Stop. The only test which we can legitimately apply in dealing with this part of the respondent's case is there any evidence on which a finding can be made against the respondent that charge was proved against him. Stop. In exercising its jurisdiction under Article 226 on such a plea, the High Court cannot consider the question about the sufficiency or adequacy of evidence in support of a particular conclusion. Stop. That is a matter which is within the competence of the authority which deals with the question, but the High Court can and must inquire whether there is any evidence at all in support of the impugned conclusion. Stop. Now, in this state of the evidence, how can it be said that the respondent even attempted to offer a bribe to Mr. Rajgopalan? Mr. Rajgopalan makes a definite statement that the respondent did not offer him a bribe. Stop. He merely refers to the fact that the respondent took out a paper from his wallet and the said paper appeared to him like a 100-rupee note double folded. Stop. Undoubtedly, Mr. Rajgopalan suspected the respondent's conduct and so made a report immediately. Stop. But the suspicion entertained by Mr. Rajgopalan cannot in law be treated as evidence against the respondent, even though there is no doubt that Mr. Gopalan is a straightforward and an honest officer. Stop. Though we fully appreciate the anxiety of the appellant to root out corruption from public service, we cannot ignore the fact that in carrying out the said purpose, mere suspicion should not be allowed to take the place of proof, even in domestic inquiries. Stop. It may be that the technical rules which govern criminal trials in courts may not necessarily apply to disciplinary proceedings, but nevertheless, the principle that in punishing the guilty, scrupulous care must be taken to see that the innocent are not punished applies as much to regular criminal trials as to disciplinary inquiries held under the statutory rules. Stop. Over.